Welcome to For Better or For Court, Family Law in New Jersey.
Welcome back to For Better or For Court, Family Law in New Jersey with Ms. Alix Claps. Alix is a partner at Heymann and Fletcher and a certified matrimonial law attorney who helps New Jersey families handle divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about appeals, specifically when and how a family court decision in New Jersey can be challenged. Ms. Alix, welcome back.
Good morning. How are you?
Oh, well. So, Alix, can someone automatically appeal a divorce or custody decision if they disagree with it?
It depends on the nature of the decision. So if it's a final decision, and again, final is a tough word in family because is anything ever really final when you're talking about kids who have varying needs along the rest of their lives? But if you have a decision made at the end of a trial, a plenary hearing, that's automatically appealable. If you're appealing the entry or the denial of a final restraining order, which is also in family, that's automatically appealable. Interim motions, depending on what they actually decide, if they solidify one issue entirely, then those are automatically appealable. Anything that is considered a final order is automatically appealable.
So, Ms. Alix, what kinds of family court orders are eligible to be appealed in New Jersey?
So if you have an order that resolves one issue completely, that's what's called appealable by right. That can be at the end of a trial, that can be at the end of a motion that fully addresses a single issue. You can also request leave to appeal what are called interlocutory orders. So an order on an issue that might be quote unquote temporary or an interim order that may get addressed at trial down the line, but that sets up a situation that you feel like is untenable or is going to create problems that aren't going to be able to be resolved by the trial. You can seek permission to appeal that. Sometimes less of this in family, more of this in civil, where there are orders that impact the way you are able to proceed to trial. So evidentiary rulings, subpoenas, documents you don't have. And you're saying, well, if I don't appeal this now, I'm going to go to trial and I'm not going to have what I feel like I'm entitled to have to prove my case at trial. So we're going to appeal it at the end anyway. We might as well appeal it now, get the ruling, and then not have to do the trial twice. So those are the kinds of interlocutory appeals that might get granted.
What is the difference between, simply being unhappy with an outcome and having valid legal grounds for an appeal?
So what clients don't always understand is that an appeal is not a do-over. It's not a chance to represent your whole case to the court. What you're appealing are very specific determinations of law. And then how your facts get applied to the legal determination, that's an outcome, but that's not what you're actually appealing. What you're appealing is the judge's decision on this is what the law means. And so if you need the appellate division to say, well, judge, you got the law wrong, so therefore XYZ changes as a byproduct, that's the appeal. You're not going and redoing the trial before the appellate division.
What does that appellate court, actually review? Are they just rehearing testimony or just strictly at whether the trial court, made a legal error?
So they're really only determining whether the trial court made a legal error. Now, sometimes it has to do with how the court handles the evidence and handles the facts and applies that to the law. But usually it's about an interpretation of the law. So the appellate division is provided the entire trial transcript. That's a requirement, or motion transcript if it's a motion that's being appealed. But what they're reading, what is new, the arguments that they're reading are the appellate briefs about this is what the trial court got wrong and here are the reasons why. I've got the statutory authority, I've got this pre-existing case law, I've got sometimes other information that the legislative record or sometimes it's sociological data, something like that, or scientific information. If you're dealing with, what is expert science or not, depending on what you're dealing with, that's what you're actually presenting to the appellate division for them to make their decision.
How important is the trial record when it comes to an appeal?
It's extremely important in part because it is at the trial and during the trial process that you are preserving your right to appeal. If the court makes a decision and you don't object in the moment, you are considered often to have waived your ability to appeal that issue. And the appellate division is not going to hear it. So if the court makes a ruling about a witness being able to testify or not being able to testify, or certain evidence being admissible or not admissible, and you don't argue about it at the time, the appellate division is going to say, well, you didn't raise it below. So you have a much higher mountain to climb at the appellate level.
What is the timeline for filing an appeal in New Jersey family law cases?
So notice of appeal needs to be filed within 45 days of the issuance of the order. We did have some problems during COVID where, for example, we got an oral decision in June of 2020, but none of us received the physical order until February of 2021. And so that was appealed, and we had to make it clear. Nobody disputed it. It wasn't like I got a copy and my adversary didn't. We acknowledged, even though this order relates back to June of 2020, the date that matters is the February 2021 date that we all received it. So 45 days from when you received the order. There are circumstances where an additional 30 days can be granted past that 45. But if you don't get it done within that 45, you risk the possibility that they're going to say, no, we're not giving you the extension. You don't have good cause. Too bad, so sad.
How does the appeals process differ from filing a motion for reconsideration or a motion to modify an order?
In addition to the deadlines being different, so a motion for reconsideration has to be filed within 20 days. A motion to vacate or a motion to modify an order, sometimes you have up to a year, depending on how that works. If you're doing a 4:50 motion, I think it's a year deadline. But a motion for reconsideration, you can make an argument based on facts, and that you can't do at the appellate level. So if your argument is that, well, Judge, you got the law right, but you missed this entire section of evidence or this fact, or we have this new fact now that wasn't available to us when we filed the motion initially, or you heard the testimony initially, and we want you to reconsider your decision in light of this information. That's something that the trial court can do that the appellate division does not do. It doesn't take new information into account or say, well, we don't give enough weight to this information.
What standard of review does the appellate division apply in custody cases versus financial matters?
So it's not really the type of case that causes the distinction. Generally, trial court, family court decisions are subject to an abuse of discretion appellate level review, which means unless the judge really got it wrong, it's standing. And part of that is because, as we've said, family courts in New Jersey are a court of equity. So determining what is fair or equitable, not strictly what the law says. There's a fundamental fairness aspect, especially when you're talking about a full plenary hearing where you've got different elements working in tandem to come up with a whole order. Strictly legal determinations by the court, those can be subject to de novo review, which means the appellate court looks at it completely fresh. But that's a very narrow section of a family appeal in most instances.
Are appeals commonly in family law, or are they relatively, rare compared to the other types of litigation?
I'll say they're rare insofar as so are full trials in family. Like a divorce trial is rare. It happens in, let's say 5% of cases, and that might even be high. If you and your spouse are so far apart that your case goes to trial, then I think there's a pretty high chance that that is going to the appellate division. Sometimes there are appeals on single issues, motions, post-judgment things that are done, even if there's been no plenary hearing. The highest proportion of appeals, though, I think, and I have no statistics to back this up. This is my experience. My gut instinct is restraining orders. Because you go into those hearings with so little discovery, there is so little discretion afforded a trial judge to craft what might be an appropriate outcome. It's sort of an all or nothing proposition. So if you lose at the trial level, it is generally worth it to take the appeal. And I think that's how the calculus operates for most litigants who take the appeal, because it's expensive. And there's definitely a cost-benefit analysis. There are probably a lot of people who would prevail on appeal, but it would cost them more than they would get in the end, and it would take a lot of time and a lot of effort. And that is something worth weighing.
So, Alex, without sharing, identifying details, can you describe a case where an appeal significantly changed the outcome for a client?
A lot of the times when I'm doing family appeals, I am representing the person defending the lower court's decision. So most of my clients did the heavy lifting before the trial. They had the outcome. So we have to defend the outcome. And sometimes if the other side's going to take the appeal, then maybe we'll make a counter argument. We'll file a cross appeal on a certain issue that we weren't happy with. But ultimately, most of my clients do the heavy work before the appeal. I'll say there was one appellate decision that I was involved in where the question became a matter of, does this other appeal that just happened, that the Supreme Court just weighed in on, how does that affect other cases? So that appeal became about something larger than the issues for just that one client. That decision got published, and that has to deal with pipeline retroactivity when a statute is amended. So it was bigger, it was important, and it ended up being bigger than that one case. But that client, again, she had done the heavy lifting at the trial level.
So for someone considering an appeal, what is the important thing they should understand before moving forward?
I think it's important to understand that the appeal of your issue is rarely just about you. You might have heard that old adage that bad facts make bad law. So when you're going to an appeal, what is going to happen is that your case and your specifics are going to be considered more broadly, because a decision made by the appellate division can be impactful on other cases. So sometimes I'll have a conversation with a client about, this is an important issue and there is no case law on this issue. So in order for us to have a decision, that's why this has to go before the appellate division. And we wait for other people to bring an appeal to say, okay, this is an issue I don't have any case law about. I need somebody to bring it up. An appellate decision is bigger than the individual case.
Oh, Miss Alix, thank you so much.
Thank you, Evan.
Sweet. That's a wrap on today's episode on For Better or For Courts. If you're considering challenging a family court decision in New Jersey, visit HeymanFletcherLaw.com to connect with Ms. Alix Claps and understand whether an appeal may be appropriate in your situation. Don't forget to like, subscribe to the show, and share this episode with someone who might need it. And we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.